guess what? In a divorce doesn't have to be a fight. In Florida, we use what's called equitable distribution. It's a pretty straightforward way to divide both what you own and what you owe. Because you built a life together, and now you need a fair, calm way to unbundle it. No games, no guessing, just a plan that makes sense. So don't worry, I've got you. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group here in Miami. Our mission is to make lives better in and out of family court. Our firm has handled thousands of family law cases, and in my 20 plus years of practice, I have seen almost every kind of equitable distribution scenario that you can imagine. So here's what we'll cover in this video. I'll show you what counts as marital versus non-marital property in Florida. I'll explain how we value homes, retirement, businesses, and debts in plain English. I'll show you how courts divide things fairly and why equitable and fair doesn't always mean equal. We'll also walk through a side-by-side example and clear up a few myths. And I'll give you next steps so that you can move forward with confidence. Just know that we're talking about Florida divorces, and this isn't legal advice for your specific situation. For that, you need to talk to a Florida family law attorney like one on my team. Now, when it comes to equitable distribution, there's 3 big steps. We classify, then we value, and then we divide. So let's start by classifying everything you own, and each debt you owe is either marital or non-marital. Marital usually means acquired during the marriage. That could be tangible assets like cars and furniture, savings that you put together during the marriage, retirement contributions and how those contributions grew during the marriage, the home equity that you gained during the marriage, appreciation and the value of a business, mortgages, student loans, and credit card balances taken out during the marriage. It doesn't matter whose name it's on. And for things that grow in value, like homes, investment accounts, and a business, it doesn't matter if you owned it before the marriage. Unless you have a very clear prenup, any of the growth that happened after the date on your marriage certificate becomes marital. Non-marital usually means you either had it before the wedding, it was a gift or inheritance made to you alone, or it stayed separate under a valid prenuptial agreement or postnuptial agreement. But here's where people get tripped up: commingling. If you mix a non-marital asset with marital money and assets and use it like joint money, it can become partly or fully marital. Let's say you had $20,000 in savings before the marriage, but then you dropped it into your joint bank account for both of you to use, and you've done that for years. That money is now commingled, and all of it will probably be considered marital. Another common issue is appreciation. If a non-marital asset grows in value because of marital money or marital effort, the increase can also be considered marital, even if the base asset wasn't marital. So let's say you owned a condo before you got married. During the marriage, the mortgage is paid with marital income and you renovate the kitchen. The growth in equity tied to those payments and improvements can be considered marital, even though the condo started out as non-marital. Another example would be the $30,000 you had in a 401k before the wedding. That $30,000 and the growth on it is yours, but any contributions after you're married and growth on those contributions is marital, even if it only comes out of your paycheck. Timing matters. To decide what falls into the marital bucket, Florida law looks from the date of marriage to a cutoff date, which will typically be the date that one party files for divorce. Once we know what you have and which bucket it belongs in, we're ready for step 2, assigning a value. Ultimately, valuation is just a numbers game. We're looking to assign a hard cash value to every asset and every debt. Here are some of the most common assets and debts we see and how we go about giving them a fair and reasonable value. For homes and real estate, we can use a neutral appraiser or the sale price if you're selling. Then we figure home equity by subtracting any mortgage and any liens. If one of you keeps the house, the plan will typically factor in an equity buyout of the other one. But if both of your names are on the loan, you'll usually have to do a refinance, so no one stays stuck on a mortgage they don't control. If a refinance is impossible, and in our current market, it can sometimes be tough, the court may require you to list and sell the house, then split the net after the closing costs. For retirement and investment accounts, it can get a little bit tricky. Like I mentioned earlier, the marital portion is the contributions and growth during the marriage, and that may mean we have to get a neutral financial analyst involved. For a 401k or a pension, we have to get what's called a QDRO or a qualified domestic relations order to move the marital share to the the other spouse without taxes or penalties. For an IRA, the transfer is different, but the idea is the same. We split whatever the marital portion is. Next, if a business matters in your case, we'll bring a neutral valuator. They look at income, market comparables, and what's tied to personal effort versus passive factors. Most of the time, the operating spouse keeps the business and the other spouse receives an offset in cash or other assets. That way, the company keeps running and the split still feels fair. And the last big piece are the debts. Marital debt is usually debt taken during the marriage, even if it's only in one spouse's name. For credit cards, the cleanest path is to close the joint accounts or balance transfer so each of you leaves with accounts in your name. For cars, we look at a trade-in or private party value, then subtract the payoff. Who keeps the car usually keeps the loan, and we balance that in the final split if we need to. Those are generally the big assets that we look at, but we can get down to smaller things if they have a significant value. These could be things like collectibles and golf clubs or jewelry and designer purse collections. A lot of times those things offset each other, but I have seen cases where we had to get them appraised. And sorry, even if they were a birthday present, gifts between spouses are still marital assets. Now that we know what's marital and what the values are, we're ready to divide it. Florida uses equitable distribution, which means we usually start with near equal value to each spouse, but equitable means fair, not always identical. Here's how that looks in practice. If one spouse keeps the house, the other may receive more of the joint savings. If one spouse takes a car with positive equity, we balance that with more of the marital debt. It may not come down 50-50 to the last exact penny, but we generally get it pretty close and within reason. But there are cases where one spouse does walk away with a lot more of the assets. A major factor in that is what's called dissipation of marital assets. If one spouse was secretly spending marital money on things like gambling, drugs, or an affair, the other spouse is typically entitled to get that back in the division. The division is also negotiable. For example, one spouse may choose to take more in the assets rather than receive alimony that they may be entitled to. It's also important to understand that generally the conditions of your divorce aren't going to factor into the division of your assets. You may feel like you deserve to get so much more than your spouse because of all the hard years you suffered in silence or put up with nonsense. But the law in Florida doesn't work that way. When it comes to equitable distribution, it really just comes down to the numbers. Now let's go through some quick scenarios. Jim and Martha got married young and have a small starter home. They each have a car and a 401k and a few credit cards. First, we determine the marital values of the 401ks and equity in the cars. Let's say that was $200,000. Then we subtract the debt. Say that was $20,000. So far, they should both be getting about $90,000 in value. So we have them both keep their 401ks and their cars, and we transfer balances on the credit card so the equity they both end up with is $90K. Now for the house. Neither one of them can afford the mortgage on their own, so the house goes up for sale. After paying the mortgage and the selling fees, there's $300,000 in proceeds. Jim and Martha both get a check for $150,000 at the closing table. But let's change it up a bit. Let's say that Martha wanted to keep the house. Well, if after an appraisal we find there's $300,000 of equity, Jim is still entitled to $150,000 of it. Martha is going to have to refinance the house to get Jim's name off the mortgage, so we do a cash out to give Jim his share. Otherwise, Martha would have to transfer part of her 401k to Jim through a QDRO. Now, there are a lot of other scenarios we can go through, way more than we could cover in one video. So just remember, it all comes down to the numbers. We classify everything as marital or not marital, we determine the values, and then we divide the total value equitably, but not necessarily equally. Now, it's hard to go into divorce knowing what the equitable distribution may look like in the end, but now at least you understand the process. And understanding that process is a big part of being ready to move forward if divorce is your only option. But it's definitely not the only part. If you want to get a good idea of all the major considerations you should be making before thinking about a divorce, take our divorce readiness quiz. It's free, it's private, and it only takes a few minutes. It will help you to see the bigger picture and understand if you're ready or if you really have a lot more to think about. The link is in the description. And if you know you're ready, you can always schedule a free case evaluation with my team by calling our office or using the form on our website. In our next video, we're going to take a look at uncontested versus collaborative divorce. They're two peaceful paths that keep your divorce out of the court. We'll compare the requirements, the costs, and the time, and how to choose the lane that fits your family best. Until then, I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group, where we make lives better in and out of family court. See you soon.